And welcome everyone to another episode of Broken Families, where we host conversations on divorce, parental alienation, and high conflict relationships. My name is Andrew Faulkner.
And I'm Barbara Lapointe. Today we are going to discuss child custody, and that is why we have brought on a very special guest speaker to help us really dive deep into this topic. Misconceptions is a family law attorney who has been helping divorcing couples for over 10 years. Marco has a 90% focus on divorce and family law, and the remaining 10% on cases relating to guardianship. He also has experience in mediation and was the chief mediator for Utah Mediation Solutions for a number of years prior to becoming a family law attorney. Marco's passion lies in helping couples consciously uncouple and to help them build a life that is better for themselves and their children. So without further ado, welcome Marco to the Broken Families podcast.
Thank you very much. It's good to be here. I appreciate it.
We're really looking forward to a valuable and relevant conversation with you for our audience, and so happy you're here. I'd like to begin by asking you, Marco, what are some common misunderstandings of child custody that parents have when they start a divorce?
There are many of them. So let me take a couple of them. I think on the legal side of things, so when people start either a divorce or a paternity case, so in Utah we call it a paternity case, which is really a child custody case where the parents were not married, they can sometimes think that the first thing that's filed with the court is an order of the court, right? That it governs behavior, and it does not govern behavior. So the first thing filed with the court, whether it's a divorce complaint or a paternity petition, is just a wish list. So people come in and they say, this is what I want to have happen. This is what I want to happen in my divorce. This is how I want child custody to go. This is how I want the debts and the assets to be allocated. But that's not an order of the court. That's just a wish list. And then one person gets to send that into the court, and then the other person also gets to send their wish list into the court, right? So I've had many times when people come in and they say, well, I filed this, so this is the way it's going to go, and I'm like, that's not how this works at all. That's just your wish list. Then the other person gets to say their piece, and then we get to negotiate it out, or we get to go to court and we get to fight about it. So that's one misconception that people have with with divorce and child custody. And why would they know any different, right? Like they don't go through this. It's the one and only time they'll ever go through this in their entire lives. So it's fine, but that is a misconception. And then I think the other misconception that happens, this tends to happen with women more than it does men, because women are usually the ones that are in charge of, the primary parent, right? They mostly do the things with the children, the kind of nitty gritty. And this is the way it is in my marriage as well. So a lot of women will just assume, because they're mom, that they get a certain amount of time with the children, or they get to say what's going to happen with child custody. So, back in the 70s and the 80s, that was exactly how it went. Women almost always got the vast majority of time with children, kind of no matter what. I was talking with a friend of mine who's a cop in Philadelphia back in the 70s and the 80s, and he actually got primary physical custody of his children because his wife had some very serious problems. But he told me, even with those very serious problems, like he told me that what he had to go through in Philly in like the 70s and early 80s to get custody of his kids. And it was absolutely like amazing what that man had to go through. And he's a good guy. So very, very different nowadays. So that is no longer the presumption. Just because you're a female, you do not get to just say what happens with the children. Now, I'm not saying that all women are like this. Most women, in fact, not like this, but that is a misconception that I see with a lot of mothers.
I find that just as women, we're so conditioned to think that way. Even we might not even realize how deep our conditioning is, but I also see that conception as I walk through the world, as I operate in my coaching practice, and I had that misconception as well. So things have changed, and some people aren't caught up to that change. So that's really interesting, Marco. Yeah.
Yeah. And it makes sense because, again, most of the time women are the ones doing the kind of nitty gritty with the kids. So I get where women are coming from on this. And I have about 50% of my clients are female and about 50% are male. So I totally get where they're coming from. It's just not that way anymore. So I have to tell them, like, okay, so this is not how this is going to work. We're going to have to really negotiate, and we're going to have to come up with evidence, because it's not just what you want to have happen. Like, we actually have to prove that you should have this much time with the children. And that's part of my job as a divorce attorney.
Fantastic. So just to invite you to talk a little bit more about important things with respect to custody for any gender, because it's such an important topic, and sometimes it takes up a lot of the time in litigation, I would imagine, too.
Yeah, it absolutely does. So the most important thing when I sit down with somebody and they ask me what's the most important factor in a judge deciding who gets the kids or what the time sharing arrangement is going to be, I always tell them, look, it's two things really. One, who the primary parent is. So who spent the most time with the children, who's put them to bed, who does homework with them, who takes them to the dentist, who goes to parent-teacher conferences, these types of things, right? The day-to-day with the children. And then the second is, what's the status quo? So if, let's take this example, a dad, and I'm not picking on dads here. I can reverse the sexes, and the analysis is exactly the same. But let's say that dad travels a ton, right? He's gone for like 3 weeks out of the month, and mom is, a traditional stay-at-home mom with the children. So that's the status quo. And then if they get divorced and dad says, well, I want the kids 50-50, and you're like, well, dude, you travel three weeks out of the month. That's not going to work, right? The court's going to say, what is this everything in the children's lives? So those are the two most important things: the status quo, and then who is the primary parent. There are lots and lots of other things that go into the analysis. Drug history, alcohol abuse, domestic violence. There are lots and lots and lots of factors. How connected a child is with the parent, so on and so forth. But the main two are the status quo and who the primary parent is.
Very valuable, really helpful. And
it sounds like people are looking for that one. I mean, I guess the common word for it was always silver bullet. They're always just looking for that one simple answer, so that way they can be like, oh, here we are, bang, and now I win.
Yeah, and I wish that existed, to be honest with you. We're human beings. This is kind of what we do. This is why politics is really weird a lot of times. Like, people will make an argument and they're like, okay, well, I win because I made that argument. Well, no, there are lots of different arguments, right? So as human beings, we like to distill something down to one point that's dispositive. I would say dispositive or wins, but that's just not how this works in the law. These cases, the work I do when I sit down with families and I sit down with people every day and talk about their particular situation, what got them here, what their kids are like, and really trying to help them get through this process and do what's right for their children. Like that is, they're extraordinarily fact intensive and extraordinarily complicated situations and cases. And that's why we have to go before judges and we have to tell them all of these things. And a lot of people will kind of decry family courts because I go before them and I can't tell what's going to happen. They seem to make contradictory rulings from one case to another. And the reason for that is it's so fact intensive. Every family is different, that you just have to make determinations based on these facts as they exist right now in that family. That's really, really difficult. And you do not get a silver bullet out of situations like that.
I think this one of the reasons we love doing this podcast and hearing all these valuable points you just made is that so people can educate themselves, be more prepared before they jump into divorce. Like even that term you just used, status quo. I remember the first time in my own divorce, I heard the word status quo and I just sloughed it off. I said, yeah, I don't, status quo. Ugh, I didn't want to hear it, but that is a term that you hear frequently in family law. So I thought that was a really valuable offering. Just good to know. So you're more familiar with the languaging when you enter into a divorce or a legal process. What else do you recommend for couples or for anyone just to get a little more prepared before you file for divorce? Because I personally think having a little bit of an exit plan or a strategy before you retain a lawyer is advantageous. Do you agree with that?
Yeah, I definitely do. And I need to apologize real quickly. If I use words that are lawyerly, I apologize. Like I try very, very hard not to do that. I spent years and years trying to kind of hone my language as an attorney to not sound like an attorney when I talk to people who are not judges and not attorneys, right? So if I use status quo and nobody knows what that means, I apologize. I try to define it. Really, status quo is just what's been happening before you actually go into divorce, right? Yeah. There are some things that they're called terms of art in the law that we have to use and they're usually Latin terms a lot of times because they have specific legal meanings, but I tried very hard not to do that. So I apologize if I did it. As for what you should do in order to prepare for a divorce, the first thing I tell people when they ask me this question is get your finances in order. I can not explain to you. I've met with over 10,000 people at this point in my career. I cannot explain to you how many people come in and I ask them, how much money does your spouse make? And they have no idea. They literally don't know how much their spouse makes. A lot of people don't actually know how much they make. They kind of know, but they're not exactly sure. But a ton of people do not know how much their spouse makes. Even basic financial questions, they don't know the answers to. So when you go into an attorney, if you know your numbers, if you know if you own a house, like you know what you owe on your house and what the equity is in your house, you know you have 401ks, like how much do you have in the 401ks? How much do you make? How much does your spouse make? What did you pay in taxes last year? Do you have any other property? You can answer these types of questions. You know, what are your debts? Like how much do you have in the credit cards? How much do you owe on your cars? You have that. Then your discussion with your attorney, when you sit down with them, is going to be really, really massively productive. Okay, because money people fight about two things in divorce. They fight about kids and they fight about money. And if you know your numbers and you can have that productive conversation with your attorney during a consultation, you're going to get a much better idea of the end of your situation right then in the beginning. So that's the first piece of advice I give to people is have your numbers in order and like write them down. So you know exactly what these things are and you can just kind of, you can just go through with the attorney you're meeting with and say, okay, this is the debt, these are the assets, these are the cars, so on and so forth. So that's the first. And then the second is figure out how much time you actually spend with your kids, right? Like figure out that status quo, especially if you're separated. So if you're still living in the same place, it's a little bit different if you're still living in the same house. But if you've been separated and then you've been kind of shuttling the kids back and forth with time sharing for the kids, then figure out how much time the kids have been with you since separation and figure out how much time the kids have been with your spouse since separation. Because that is really the status quo question. And if you get a calendar, like people who come in with calendars saying, oh, the kids are with me on Wednesday, Thursday, Friday every week, whatever that might be, that is gold for me as an attorney. I can really help people to lock down, what child custody is going to look like if they've been separated for 6 months and they know exactly how much time they've been sharing during that period.
Those are two really empowering golden tips to be more productive with your attorney and save yourself some money too, so you can create some forward momentum it's not hard for me to believe that clients would come in and not know their finances or not know exact numbers.
They have no clue most of the time. No clue.
Amazing. That was really great advice. Wow. Okay.
So with that said, what are your thoughts on prenup agreements prior to marriage?
Yeah, this is a great question. So I'm going to wear two hats during this question. One hat is going to be like Marco, the guy, and then the other is going to be Marco, the attorney. So Marco, the guy, has been married for about 20 years. On the 15th, it'll be 20 years. I got married when I was 24 in college I'm from Alaska, this girl's from Texas. We meet here in Utah when we're going to college and get married. And we kind of grew up together, right? We got married when we were 24, so we kind of became adults together. I love my wife a ton, and I'm really glad we're still together, and we have 3 kids. If my wife were to die today, one, I probably wouldn't get married again, because I like marriage because I like my wife. But if I were to get remarried, I probably wouldn't do a prenup on a personal level, because that's just a decision I would make. I would either want to trust that woman that I'm marrying implicitly, or I'd rather just not get married. But that's just me as a human being. That's the decision I've kind of made for myself, right? But as an attorney, look, if you have a prenup, really, really works if you have money. It's very necessary if you have money. So if you got $1 million, if you got a couple $1 million, something in excess of that, and you want to make sure that the other person is not marrying you for money, then get a prenup, and that's totally fine. If you think the prenup is going to hinder the marriage going forward and put you at a disadvantage from day one on an emotional or spiritual level with your new spouse, then think very, very seriously about not doing it. So I'm a little agnostic when it comes to prenups legally. We don't do a lot of them here in Utah, to be honest with you. I know in other states, because I can only speak specifically to Utah law, but in other states, I know that the law is different, and they do a lot more prenups because of the way the law is structured. So in California, I have a very good friend who's a divorce attorney in LA County, and she does tons and tons of prenups because the divorce laws in California are just absolutely bonkers, like a lot of other things in California. But she does a ton of them, right? And it's very, very common. The culture, it's very common to do a prenup. The law is structured in such a way that a prenup makes a lot of sense. Here in Utah, it's much less so. So it really depends. But again, and I'm just repeating myself a little bit here, but if you have $1 million, $2 million, those types of assets, and you want to be sure about your marriage, that it's on the up and up, yeah, go get a prenup.
Amazing. So Marco, we've talked a little bit about custody. We've talked a little bit about preparing for divorce in advance, a prenup. I'd like to now ask you to talk and share with us your views as a lawyer on 50-50 custody. Does it happen? What are the pros and cons of 50-50 custody? Anything we should know about 50-50 custody from your perspective?
Yeah, this is a hot topic in divorce law. So like I said, back in the 70s and 80s, 50-50 was not a thing. Okay, it did not happen. So mostly women got probably 90% of the time with the kids, and the dad would get like 10% of the time. That was horribly unjust in a lot of situations, and thankfully we rectified that. So but the problem is the pendulum always swings way to the opposite side, right, before it comes back to where it actually makes sense. So in a lot of states, they're getting to a mandatory 50-50 between the children, between the parents. And I've actually thought a lot about this because I represent a lot of men. I am a man. I represent a lot of men. I represent a lot of women. I've done this. I've helped thousands of families. And I think that 50-50 can work, and often does work for kids, and is often what's best for children. Okay. But in a lot of situations, it is absolutely not what's best for kids. I mean, if take the example I gave before, dad's gone for 3 weeks and mom stays home with the kids all the time, and that's just the way they structured their marriage. and then they get divorced, and dad still travels 3 weeks out of the year, but the court says, well, do a 50-50 because that's just the presumption that we made, is that everybody gets 50-50. So those kids are like with a nanny for a week and then with dad for a week instead of being with mom for the time that dad's gone. That's probably not in the kid's best interest. I don't think that's going to be a great situation for them. So the pendulum in some states have swung to the side of like, we have to do 50-50 for these children. And I don't believe that is the case. It's much more complicated than that. I know a lot of people who will say, and I've had this conversation with many, many people, they'll say, well, the research says that 50-50 is best for kids. I'm like, okay, great. Like I read research all the time. Show me the research, right? I was going to be a clinical psychologist before I became a lawyer. So, I've read hundreds and thousands of studies. So show me the research. So I read the research, and the research does not indicate what people say it indicates for the most part. What I've seen in the research is that children tend to do better. They tend to do better when you have kind of a closer to 50-50 type of setup. Really, the way they define it in the research that I've read is about 35% to one parent, about 65% to the other parent. Kids tend to do a little bit better. But even the magnitude of how much better they do is not great, right? The magnitude's probably like a 0.2, which is, in social psychology and in psychology, in the social sciences in general, which isn't that bad. But I'm talking statistics a little bit here, but it's really not all that great. It doesn't explain a ton of the variability and how well children do. So I hear that argument a lot, and I'm not really convinced of that. So it gets back to like, how are these particular children going to do with this type of time sharing arrangement, right? It's going to be better at a 70-30 or a 60-40 or a 50-50. And that is a really long way of answering that question. But I've been asked this question a lot over the last year. I actually went and talked with some legislators in Utah because there was a law mandating 50-50 between the parent, 50-50 custody between the parents. And I went and I talked to them, and I said, this is a bad idea. The way this is written, the way this is done, this is a very, very bad idea. And thankfully we were able to get that changed and make it a little more sane. Again, I'm not saying that 50-50 is bad. We do 50-50 for a lot of guys and a lot of ladies, and it makes sense. It makes sense in a ton of cases, but in a lot of them, it absolutely does not. And we have to get down to the children and what's actually going to be best for them, and look at their attitudes, what's been happening, and see whether or not it is in fact best for those kids.
The impression I'm getting is like, because I see this a lot in the parental alien movement. I see this a lot in the parental alienation movements, where they push for legislation for either 50-50 or even mandatory 50-50, without realizing that they're pushing a blanket solution on something that's going to be a case-by-case basis. Would that be a correct assumption?
Yeah, I think that's very much correct. So the legislation that was here in Utah, I can speak to that, it was 50-50. It was assumed to be 50-50, kind of no matter what, for the most part, unless you could show by clear and convincing evidence. It's a very, very high standard in civil law. Like it's just under reasonable doubt in the criminal law, right? It's very hard to get to show clear and convincing evidence. So unless you showed clear and convincing evidence, it was going to be 50-50, which is absolutely ridiculous. And it would have been terrible for tens of thousands of children here in Utah. So thankfully we were able to get that changed. But you're right, people want to say that, okay, it's the standard. And what it is, as far as I can tell, talking to people about legislations like this and talking with people just in general, is that it's this backlash to the 70s and 80s where guys, yes, absolutely got screwed out of tons of time with the kids. And that was bad for those children. So they kind of want to swing that pendulum all the way to the other side, which is just as bad. Like we can't be doing that sort of thing. So the way I think about this, from the research I've read and my experience as a divorce attorney, you kind of come up with a situation where, yes, a parent should have a significant amount of time, and we should assume that both parents have a significant amount of time with the kids, at least 30% of the time with the children. And then after that, like, we just make that kind of assumption in the beginning, but we can get off of that. Maybe there's domestic violence in the house and one parent and drug abuse and all these things, and one parent really shouldn't have time with the kids because the parent is an actual safety hazard to the children. Or there's been alienation, and we need to figure out what that alienation is and reverse the custody, right? But we can make those arguments, and we can make them specifically based on this family and this family's particular facts. So that's how I see it.
I often ponder that 50-50 custody is more challenging in a high conflict scenario. Yeah.
Sorry, it can be.
I'll take that as a yes.
I was anticipating the question instead of waiting for the question. I apologize for that. But yeah, it certainly can be. So if you have a very, very high conflict, between the parents, right, you're still going to do a 50-50, which can work. Then the best way to do it is to live parallel lives with the kids, right? It's parallel parenting. So you don't really talk with each other. And we do this all the time. We structure our clients' divorces in this way all the time. So for example, the kids, it's a week on, week off schedule. So the kids are with one parent for a week and with the other parent for a week. And on Monday afternoon, when the children are finished with school, that's when the switch is made. So the other parent just comes to school and picks up the kids, right? Or the kids go to the parent's house, whatever the case may be. And in that way, the parents never actually see each other, and they never really have to talk, which in those really high conflict situations is going to be the best thing for the kids. Now, the best thing for the kids is for the parents to act like grown-ups and get over it and interact with each other and discuss the children and figure out just figure out their crap with each other and not bring that into the kids' lives. But we're human beings, and that's not always the way it is. So if these people hate each other and they have so much conflict that it really does bad things to the children, just live parallel lives and just don't talk. And we can structure divorces to make that happen. We do that all the time.
Interesting. So no matter what unfolds, whether it's parallel parenting, certain different ways to structure custody, once you get that agreement in place, sometimes parents violate visitation agreements. And so I was wondering if you had any counsel for that, if someone finds themselves in a position where the other parent is not being friendly or being a friendly parent or honoring those agreements in place.
You cut out just a little bit. I think what you asked was and correct me if I'm wrong about this, what should you do when you have an agreement, like you have a divorce decree, exactly, and then the other parent just doesn't follow it? Is that what you're asking?
Correct. Yes, exactly.
Okay. So there are a couple ways to deal with this. The most effective way I've found is to work with the other parent. I know the other parent, the other parent is not following the dictates of the divorce decree, and you really want to take it to them. But the most effective thing is to really work with other parent and try to persuade them to follow the divorce decree, right? And maybe this takes a while. Maybe you have to really work with them. And that's a very, very difficult thing to do because you don't want to work with them anymore because you divorced them for a reason. But that's how I found that's most effective and has the most long-lasting positive effects for kids as well is to work together and to fix that problem without having to go to court. But sometimes you got to go to court, and that's totally fine. So let's say that the problem, this is an example, the problem is the other parent is not paying alimony and not paying child support, something simple. Okay. So we're going to go to court on what's called a motion for contempt. It's actually called an order to show cause, and say, hey, look, the contempt is that they haven't paid child support and they haven't paid alimony. So you need to pay the back amounts that you owe, and you need to pay my attorney's fees because I shouldn't even be here in court because you should have just paid me. And then you get them in front of a judge, and the judge slaps them around a little bit, and then they hopefully pay the child support and the alimony. And hopefully that changes their behavior, right? Because there's been a little bit of pain that's associated with getting slapped around and then having to pay attorney's fees. So when we go to court, that's how we would deal with a situation like that. But again, if it's a parenting problem, then really the first thing you want to try is to talk to the other parent and persuade the other parent, hey, look, let's follow the divorce decree. Let's be good to each other. Let's do this for our kids' sake. This is going to advantage us. And here's how it's going to advantage us. Here's the benefit to the kids. Talk in that kind of manner with them and see if you can solve the problem that way.
I really like that. Just to go that route first before creating conflict.
Yeah, definitely.
Yeah, don't pay attorneys unless you have to pay attorneys.
That's great.
So, Marco, recently in the parental alienation sphere, there was a video on Facebook that was getting shared around, and basically, what it was this father had driven the son to the mother's place, and the mom was standing out at the window saying, son, come on, let's go inside, let's go, and it's time for you to spend time with me. And now the father was recording this, and the son was saying, no, I don't want to. And mom got emotional. She wasn't really sure how to handle the situation. Her husband was kind of standing to the side, and eventually I believe the police were called, and the police were informing that mother, the son has the right to make those decisions. I think he was in his teenage years at the time. I don't know the full details of where they live or any of that kind of stuff, but I guess where this question is kind of going towards is at what point does the child have the ability to make those decisions?
Yeah, that's a great question. So the answer legally is 18 here in Utah. And I think it's probably that way pretty much anywhere in the United States. But in Utah, it's 18. So the kid gets to determine where to go when the child turns 18 and becomes an adult. Now, and I tell people this all the time when they come in and talk to me about this subject. When a child turns 16, that child is different than a 15-year-old or a 14-year-old, because we all remember when we were 16, right? If you're anything like me, you were just a butthole and you knew more than everybody else. And like your parents were there to feed you and like give you stuff, but you didn't really want to hang around with them. Like I was a mean teenager. I made amends, but I was not a great teenager. So teenagers kind of do what they want, right? They have a car and they have friends. They're gaining independence. They really want to just make their own decisions. Mm-hmm. So there's this idea here that you can tell a 16-year-old what to do and a 16-year-old where to go, but you can't actually make them do it. Certainly a judge can't do it. Like a 16-year-old doesn't care what the judge has to say about where the 16-year-old sleeps, right? So judges kind of recognize this. And you should never, ever take advantage of that as a parent, because if you do, you're just being a jerk and you're doing a real disservice to your teenager to teach them that they can alienate themselves from one parent, which is probably not going to work out that well. But when push comes to shove, at that point, a 16-year-old is going to decide where a 60-year-old wants to sleep and where the 16-year-old wants to be. And unless there is a serious safety concern, like a psychological, emotional, physical safety concern with one of the parents, that 16-year-old is probably going to be able to make that determination for himself or herself.
Gotcha.
Interesting. Well, Marco, we've covered some really serious topics and covered some serious points. What are the strangest things that you've seen in family law? Or maybe you have a fun story to share.
So I've often thought of. Yeah, I always have to worry. I always have to think through stories, because I obviously can't. I can't break confidence with my clients. So when I share stories, I always share stories that have been changed enough that no one can actually recognize them. But I have seen the craziest stuff of my entire life being a divorce attorney. And what's funny about it is that I don't do drama in my own personal life. Like, I've been married to the same woman. I have 3 kids. I'm kind of a boring guy, and I kind of structure my life in that way to be kind of boring on a lot of levels. But when I get to work, I need some excitement, and family law definitely provides that excitement, right? You get lots of stories and lots of crazy things happening. And that's one of the things I really, really enjoy about family law. We try not to, in my firm, we try not to feed into that, right? We're not crazy makers. And there are a lot of attorneys who are crazy makers because they think it'll make them more money. I don't like that because it hurts kids, and it tends to hurt families and takes up a lot of time and cash. But even us, just trying to get in and get things negotiated for our clients and do what's best for them and their kids, we see, crazy things. Like I remember I had a situation. I actually made the judge laugh with this one. So the other side accused my client of beating himself up. Like, it was a domestic violence situation. So the wife had beaten up the husband, and pretty badly, actually. So most women, a lot of men undergo domestic violence, and it's not something that's talked about, unfortunately. But she beat him up bad, the black eyes, the whole bit. And usually women don't do that, but in this case that happened. But we get into court, and the accusation was this guy beat himself up in order to put her in a frame, right? Which is absolutely ridiculous. So I got to go up in front of the court and say, hey, look, this is not Fight Club, and my client is not Edward Norton beating himself up in his boss's office, right? And there are like, probably 5 or 6 people in the gallery behind me that are laughing out loud. And the judge laughs out loud, and it went well for my client. I was able to make everyone laugh. And usually when I can make people laugh, they tend to agree with me. So, that's just one example of this, but there are too many examples to count of just crazy stuff that goes on in family law cases.
Well, thanks for sharing that. I mean, we're pretty selective on the podcast about attorneys that we bring on to interview, because I think I have a good gut feeling and sense about attorneys. And I always sense that you really protected and fought for your clients with integrity and passion. And I really appreciate that about you.
Yeah, we try. So I always tell people that, look, what we want to do is we want to get you in, we want to negotiate in mediation, get things done, and get you on with your life, right? That's the cheapest way to do this, the quickest way to do this, and that's the easiest way to get the outcome that you really desire and to take care of your kids. But then I tell people also, look, if we got to put on boxing gloves and break somebody's nose in court, that's exactly what we're going to do, because let me tell you, that's a lot of fun. And we're lawyers, and it's what we do. It's not my first choice, but if I have to, I'm breaking somebody's nose.
Well, it's good to know that you can do that. I like that.
Yeah, you got to carry the big stick. You don't always use it, but you got to carry it around.
Exactly. Great. Well, Andrew, do you have any more questions that you'd like to pose?
I think I got one alienation question for you, and it kind of ties into what we were talking to, that previous question I asked you earlier, was the when a parent is being alienated from the child, especially while visitation is still ongoing, that parent can feel like they're just constantly at odds with the child. The child's going to be acting out a lot of internalized trauma and a lot of frustration. And how can a parent better handle this from a legal perspective? Barbara and I give them tips and advice as far as the social elements of handling the child, but from a legal perspective, if they're being if their child is being brainwashed against them, what do they do?
Yeah, this is a okay. This might take me a little bit. If I get lost when I'm answering this, just kind of bring me back to where I need to be. But this is one of those hot topics, both in psychology and in family law, and the kind of intersection of those two things. So alienation is not the term that's used anymore. It's still used, but it's not the primary term that's used. But alienation really is the idea that one parent actively alienates a child from the other parent, right? Is trying to take that child away emotionally and sometimes physically from that other parent, right? And there are some psychologists, I don't agree with them, but there's some psychologists that say that this is just not really a thing. This doesn't really happen that often. And when I hear that sort of thing, I think, well, you only believe that because you've never been involved, like directly involved in divorce, because it happens literally all the time. So it happens actually in every divorce. The act of divorce is an act of alienation of the child from one parent. And it can be as simple as a parent doing it unconsciously. When you get divorced, you're going to speak poorly about the other parent, no matter what you do. Okay, it's just going to happen. And you try very hard not to do that in front of your child, unless you're a jerk, but you're going to do it anyway. And that child is going to pick up on that, right? And that's going to alienate that child to some degree against the other parent. So you just have to try to minimize the alienation that actually goes on. And that's what I tell people, my clients do, is like, look, don't talk about this stuff. I know it's going to happen, but try to be as good about it as possible, because you don't want to alienate the kid from the other parent, because that child sees himself or herself as 50% one parent and 50% the other parents. You're just hurting the kid. So that's kind of the baseline of alienation, that it happens all the time. But then there are those situations, and this is where it gets really sticky in psychology and in law. There's situations in which the parent actively alienates the child instead of unconsciously alienating the child, and then really, really tries hard to completely and totally sever and break the relationship between that child and the other parent. And in that situation, when that happens, that is probably the most difficult thing we have to deal with in divorce. All the other stuff we can deal with. You can deal with the emotions of the parents and that sort of thing. But when you have one parent who literally hates the other parent so much that they're willing to effectively terminate emotionally the relationship between that child and the other parent, there is nothing more difficult to deal with in all of family law. The only good way that I have found to deal with it, and we've tried every which way, you can do reunification therapy, you can do family therapy, you can do all these things. But if one parent just will not stop the alienation, the only thing you can do is to switch custody. And I've talked with psychologists about this. I've talked with other lawyers about this. And this is what I tell people when we actually get these types of cases to come in. And they're fairly rare. They're actually very rare. But when we have that type of case, then I just tell people, all right, this is what we're going to do. We have a protocol for this. We're going to get these experts. We're going to go through this process. It's going to take a year and a half at least to do this, if not 2 years or more. And we're going to switch custody. And we're going to go to trial, because that is what's going to be required in your situation. So people need to understand that if they have that situation, again, which is exceedingly rare, they're going to have to put together the money and put together the emotional fortitude to go through the entire process and just listen to whatever their attorney tells them, and pay for whichever expert their attorney tells them to pay for, because that is a tough row to hoe, and you have the hardest case in all of family law.
Oh, that's fascinating. Wow.
Yeah, and some other people may totally disagree with me about this. I know other attorneys who disagree with me about it. They think that you can just go to reunification therapy and everything would be hunky-dory. I think that's complete crap, because you go to reunification therapy, the kid's with the reunification therapist and the other parent for an hour, and then they go back to the other parent, and that other parent is on them like white on rice for a week until they go back to reunification therapy. So it's like, 200 hours of that alienated parent chirping in that kid's ear and an hour of therapy. Mm-hmm. Like, who's going to win that? The parent's going to win that, right? The only way you can fix it is to switch the custody.
Yeah, we recently had a consultant, an international consultant on who works in parental alienation, and he talked about the unknown phenomenon of how reunification therapy mostly fails most of the time. So I have to agree with you on that point, Marco. Yeah.
Yeah, and by most of the time, he probably didn't tell you. He probably didn't give the actual number, but my number would be most of the time is like 95+%.
Wow. Right.
Yeah.
Sounds-
It's a scary
It's just not
statistic,
terribly
too,
effective.
considering
Yeah, and maybe
how
I'm just
expensive it
making,
probably is too.
yeah, exactly. It's expensive. It takes a long time. And this is just my experience. So I may be off by this, but in my experience, it's almost uniformly a waste of time.
Hmm. I guess one question that's percolating in my mind is, do you have very emotional responses from your clients? Or very emotional clients where they can't they're told something like what you just said, you've got to go to trial, or there's parental alienation occurring and we have to do this, or just anything. I mean, it's such an emotional time for clients. Do you have clients that can't be a solid container for their emotions, and their emotions interfere with your productive conversations, back to productive conversations?
Yeah, absolutely. We have some of those. I tried very hard to weed those people out, and not in a bad way, like because everybody has emotions, and everybody who has those types of emotions needs somebody to help them. But I and my people are usually not the people to do that. So if somebody's that kind of overly emotional, bordering on irrational, and they have such negative emotions that they really can't kind of get past that and listen to our counsel and do what we require of them, then we're not doing them any favors by representing them. And I just try to figure that out and say, okay, here's somebody else who's going to be able to help you better, right? And serve you better. So go talk to this person, whoever that might be. But sometimes, we do have those individuals, and a lot of individuals will go through periods where they're totally, completely rational and okay, and then they just break, right? And they'll go through like a week or a month where they're not in a good place, and we just try to identify that and work with them through those times. But one of the ways that we're effective at doing that is that we don't. Again, we're not crazy makers. We're not like stoking this fire, because I know a lot of attorneys, again, who will stoke this fire and stoke litigation as much as possible. And when you do that, that tends to break your clients, right? That actually causes them to emotionally break. And it's your fault as the attorney. And that does nobody any good whatsoever. So we try very hard not to engage in that type of behavior.
I think that's such a powerful point. That type of stoking clients does stoking the fire in files, as you say, a great metaphor, will break a client over time because it's stressful.
Yep.
You're not meant to go through that stress for long periods of time.
No, we're not. If I were to, and I tell people this, if I were to divorce my wife, like I'd be an absolute emotional wreck, right? And if I just because that'd be, that like my entire world would have ended, right? And that's very, very difficult to deal with. And I'd be an emotional wreck. And if I hired some, jerk attorney who again stoked that flame, I'd fall even farther down that rabbit hole, and that's not good. And so we don't do it.
Well, Marco, we're coming to the top of the hour, and these hours always fly by so quickly. It's been so fun to chat with you. We always give our guests one chance to sort of say anything they want, or anything that's left unsaid, a pearl of wisdom, if you will, to the audience that are dealing with divorce, high conflict personalities, parental alienation. The floor is yours.
So this, I think, is probably the most important thing a divorce attorney can say to people. If you're wondering whether or not you should get divorced, do everything you can to save your marriage. Spend the money. And I tell people this. So our average divorce is between like $6,000 and $8,000. Okay. It's not like an exorbitant sum of money, but it's a lot of money. So I tell people, look, if you're unsure whether or not you want to get divorced, don't take that $6,000 or $8,000 and spend it on your marriage, right? Spend it on therapy. Do whatever you need to do to make your marriage work, because I've seen I've read I've read the studies, I've seen the stats. If you can make your marriage work, you're very likely to live a better life and a more kind of healthy, happy, meaningful life if you stay together. Now, sometimes that cannot happen, and that's okay. And and this is the second part of this. So if that can't happen and you need to get out, be proactive in it. Make the decision to get out and then act on it right then and there. So you've reached that breaking point, whatever that is, okay, act on it. Because the worst thing you can do is to reach that breaking point and spend the next 7 years wallowing in the frickin' muck and the mire and hating your life and hating your kids and hating your spouse. Like, and you also, like, when you do that, when you're not proactive, but you're reactive and you let things happen to you, you also tend to do very poorly in your divorce when it's time to go get divorced, because you're just letting your spouse do whatever they want to you, just like you have for a long time. So again, if you can save your marriage, save your marriage. Don't pay me, don't pay an attorney, spend the money to save your marriage. If that can't happen, be proactive and get out.
Absolutely.
That's amazing advice for anyone listening, because I think people don't realize often how proactive of a process it is. And I'm speaking from personal experience. It's a very proactive process. So I love how you ended our conversation with that powerful point for anyone to remember. Thank you for that.
All right.
You're welcome. And thank you so much for the conversation. It's been fantastic.
Absolutely, Marco. If listeners wanted to reach out to you, learn more about your practice, or even just learn more about you, what would be the best way for them to do so?
You can go to my website. It's www.utdivorceattorney.com. So we're in Utah right now. We're going to expand into Arizona, probably very likely by the end of the year, and then we'll expand into other states after that. So I may actually have a different website for that aspect of things. But right now, it's www.utdivorceattorney.com. Or if you're in Utah and we can help you with your case, you can call us. It's 801-685-9999.
Beautiful.
Right on. All righty. It looks like that is all we have time for today. Once again, thank you for taking the time to be with us. And if you enjoyed this episode, be sure to subscribe to our channel either on YouTube or to our podcast through the various podcasting platforms. On to you, Barbara.
Yes. And I invite you to check out my complimentary ebook, Erased by a Narcissist, One Woman's Journey Through a High Conflict Divorce. And you can find this as a free download at barbaraLapointe.com/erased by a narcissist. Andrew?
Don't forget, you can, if you want to reach me, you can email me at startnow@andrewfaulkner.com. Barbara, what would be the best way to reach out to you?
Barbara@barbaraLapointe.com.
Right on. As always, thank you for taking the time to be with us today at the Broken Families Podcast, where we discuss and help you find solutions to divorce, parental alienation, and high conflict relationships. Have a wonderful day, everyone.
Thanks, Marco. Nice to meet you.
Thanks.
That was awesome.